Welcome to SQE1 Preparation, Criminal Practice, Sentencing Guidelines by Nasir Hafizi. The learning outcomes are this presentation is designed specifically for SQE1 criminal practice students to develop a thorough understanding of how sentencing works in theory and practice. Throughout these slides, I will explore and examine specific guidelines for different offences, understand how courts apply these guidelines, and develop practical skills for working with sentencing principles in your future legal practice. Please watch all the SQE1 criminal practice classes in the series, including the ones on sentencing. By the end, I hope you will have gained valuable insights into the sentencing process that will help you prepare for your SQE1 examination and your future career as a solicitor. The SQE specification says this: sentencing, role of sentencing guidelines, determining seriousness, including aggravating and mitigating facts. And they're the two elements I'll be focusing on in this class. In subsequent classes, I'll be focusing on concurrent and consecutive sentences, mitigation, types of sentence, and Newton hearings. So please watch those video classes as well. By way of SBAQ tips and what to look out for, just as a reminder, look at time management during the assessment period. Look at focus on 1.8 minutes per SBAQ question. Flag difficult questions and return to them if time permits. Always provide an answer, even if uncertain, as there is no negative marking. Question analysis. Focus on sentencing factors like prior convictions. Look out for that. Guilty pleas, when the guilty pleas take place. Aggravating and mitigating factors, and pay special attention to statutory provisions if they're mentioned in the scenario. And common sentencing themes in these SBAQ questions are looking at specific offences, knowing the maximum sentences for those offences, the reduction for guilty pleas, concurrent and consecutive sentences, and the application of specific sentencing guidelines to case scenarios. Remember, the SBAQs often require application of sentencing principles to factual scenarios, working out basically the sentence. Practice working through examples methodically, identify the relevant guidelines if they're mentioned, and follow the step-by-step approach to determining the appropriate sentencing range. And we're going to look at that today. Test your knowledge. One, understanding sentencing guidelines, true or false quiz. There are 10 here. I'll just go through them very quickly. True or false, courts must always follow the sentencing guidelines exactly as written. Question 2 is true or false, a defendant who pleads guilty on the day of trial is entitled to a 1/3 reduction in sentence. Question 3, true or false, voluntary intoxication is a mitigating factor that reduces culpability. Question 4, true or false, previous convictions must always be treated as aggravating factors. Question 5, true or false, the maximum sentence for ABH under section 47 of the Offences Against Persons Act 1861 is 3 years imprisonment. Question 6, true or false, when sentencing for multiple offences, sentences must always run consecutively. Question 7, true or false, a pre-sentence report is always required before imposing a custodial sentence. Question 8, true or false, the sentencing range in guidelines represent the minimum and the maximum possible sentences for an offence. Question 9, true or false, prevalence of an offence in a particular area can justify a more severe sentence. And question 10, true or false, offences taken into consideration, TICs, cannot increase the sentence for the main offence. Another test your knowledge question here too. A man has been charged with making off without payment and assault occasioning actual bodily harm. The prosecution case is that on a night out, the man refused to pay for taxi fare and punched the driver several times in the face before leaving the scene, causing the taxi driver to a broken nose and bruising to his face. The prosecution case is that this was an unprovoked incident. The taxi driver was off work for several weeks. The man was convicted following a trial and is now due to be sentenced by the court. He has a previous conviction for criminal damage 6 years ago and presently works as a fireman. Which of the following matters is the court likely to consider an aggravating feature? Option A, the man pleaded not guilty. Option B, as a fireman, the man was in a position of trust. Option C, the victim was providing a service to the public. Option D, the man was not provoked during the incident. And option E, the man has a previous conviction for criminal damage. Test your knowledge 3. Tony has been charged with an offence of robbery. When interviewed, he denied his involvement and later instructed his solicitor that he would plead not guilty. At his first appearance in the magistrate's court, Tony's solicitor was given access to the prosecution evidence, which appeared to be compelling. Despite advice from his solicitor, Tony was not prepared to indicate a guilty plea at this stage. Tony's case was immediately sent to the Crown Court, and the date for the plea and pre-trial hearing, PTPH, was set. At this hearing, Tony changed his mind about plea and entered a guilty plea at the PTPH. However, he made it clear he did not show any remorse for his offending behaviour. So the question is, what level of discount will Tony be entitled to as a result of his guilty plea? Is it 1, somewhere between 0 and 1/10 discount on the sentence since he has shown no remorse for his offending behaviour? Is it answer 2, 1/10 discount on the sentence since the evidence against him was overwhelming? Or is it 3, a 1/4 discount on his sentence since he only indicated his guilty plea after the first stage of the proceedings? Is the answer 4, 1/3 discount on his sentence since he indicated his guilty plea at his first appearance in the Crown Court? Or is it option 5, Tony will not be entitled to any discount on his sentence since he has shown no remorse for his offending behaviour and the evidence against him was overwhelming? I hope those test your knowledge questions are useful. Let's look at some of the content now. Look at the 4 roles of the Sentencing Council of England and Wales. Guidelines development. What they do is they creating comprehensive offence-specific sentencing guidelines based on research, consultation, and expertise. The idea is promoting consistency, ensuring similar offences are sentenced consistently across courts and judges. Research and monitoring, conducting research on sentencing outcomes and monitoring the impact and effectiveness of guidelines. And basically public education, promoting understanding of sentencing practice among the public, media and legal professionals. The Sentencing Council was established by the Coroners and Justice Act 2009 to promote greater transparency and consistency in sentencing. It comprises judicial and non-judicial members appointed by the Lord Chancellor, and its guidelines apply to all courts in England and Wales when sentencing offenders. So what are the sentencing guidelines? Sentencing guidelines provide a step-by-step approach to determining the appropriate sentence for specific offences, considering factors such as culpability, harm, aggravating and mitigating factors. Offence categories. Guidelines typically divide offences into categories based on the seriousness, with corresponding sentencing ranges. This creates a matrix of options depending on the assessment of harm and culpability. Under the Coroners and Justice Act 2009, courts must follow relevant sentencing guidelines unless it would be contrary to the interest of justice to do so. Sentencing guidelines are designed to promote consistency while allowing judges to exercise discretion based on the unique circumstances of each case. They aim to provide transparency in sentencing process, making it more understandable for defendants, victims and the public. The guidelines are regularly reviewed and updated to reflect changes in legislation and societal attitudes. They are often subject to political controversies and public debate. And you can only just have a look at some of the news reports on some of the sentencing guidelines. What are the different sentencing guidelines for different offences? So these are just examples I've given here. So you'll have sentencing guidelines for offences against a person, assault, ABH, GBH, domestic abuse, property offences, theft, burglary, robbery, criminal damage, drug offences, supply, possession, production, road traffic offences, dangerous driving, drink driving, And then there's financial crimes, fraud, money laundering, tax evasion. So there's sentencing guidelines for these types of offences. Each guideline follows a similar structure, but is tailored to the specific offence type. Guidelines consider offender-specific factors that affect seriousness, such as the value of goods in theft offences or the level of injury in assault cases. The Sentencing Council website provides free access to all the current guidelines, which are regularly updated and revised based on research and consultation. And I encourage you to have a look at these sentencing guidelines for yourself. Must the court follow the sentencing guidelines? Well, section 59 of the Sentencing Code says this: every court must, in sentencing an offender for an offence, follow any sentencing guidelines which are relevant to the offender's case. And it goes on, unless the court is satisfied that it would be contrary to the interest of justice to do so. Very common type question in SBAQ questions, this one. The exceptions: interest of justice. Courts may depart from guidelines if following them would be contrary to the interest of justice. When departing, the court must state that it is departing from the guidelines, state the reasons for departure, and explain how the alternative sentence is justified. In R versus Healy, the Court of Appeal emphasised that the guidelines are just that, guidelines, not tramlines. They provide a starting point, very useful, and a structured approach, but the court retains the discretion to ensure that the sentence is appropriate to the specific case before it. What does seriousness mean in the sentencing guidelines? Well, the overarching principle, the seriousness of an offence determines the severity of the sentence. There are two key components to this: seriousness, culpability, and harm. And the guidelines provide a structured categories of seriousness. Section 63 of the Sentencing Code requires the punishment must be commensurate with the seriousness of the offence. Seriousness is assessed by determining the offender's culpability and harm caused or risked by the offence. Most guidelines divide seriousness into categories, e.g. category 1, 2 or 3, based on these assessments with corresponding sentencing ranges. The more serious the offence, the more likely it is that a custodial sentence will be deemed necessary, following the principle of proportionality established in the case of cases like R versus Cunningham. What does culpability mean in the sentencing guidelines? Well, culpability refers to the offender's blameworthiness or level of responsibility for the offence. It assesses the mental element, planning, role, motivation behind the criminal act. Was it a leading role, medium role, significant role? Typical categories: most guidelines classify culpability into levels: high, medium, low. Some guidelines use different terminology, such as deliberate, reckless, and negligent, depending on the offence type. The assessment of factors that typically increase culpability include significant planning, leading role in a group, activity, deliberate targeting of a vulnerable victim, use of a weapon, abuse of position of trust, commission of offence while on bail. What reduces culpability as well includes mental disorder, learning disability, age, lack of maturity, lesser role in the group, activity, genuine mistake or misunderstanding. Courts must carefully assess all relevant factors to determine the appropriate level of culpability, which will then inform the seriousness category and sentencing range. What does harm mean in sentencing guidelines? Well, harm can be categorized into four ways: physical harm, injury, death or disease suffered by the victim; psychological harm, mental trauma, distress and emotional suffering; financial harm, economic loss, property damage or financial impact; and risk of harm, potential harm that was risked even if not actualized. Harm assessments vary by offence type. So, for example, for violent offences, the level of physical injury is often determined. For property offences, the financial value or impact is key. For drug offences, the quantity and purity of drugs may determine harm levels. The guidelines also recognise that actual harm might exceed what was intended or foreseen by the offender, particularly in cases of vulnerable victims. The Court of Appeal in R versus Doe emphasised the courts must carefully assess the full impact of the offence on victims when determining harm. What does prevalence mean? Well, the definition prevalence refers to the frequency or commonality of a particular type of offence within a specific location or community. It considers whether certain crimes are especially common in a particular area. The concept allows courts to determine local conditions and impose sentences that may have a deterrent effect on others in that community. The legal basis of this is the Court of Appeal has confirmed that prevalence can be a legitimate factor in sentencing. In R versus Utterson, the court stated where a particular type of offence is prevalent in a particular area, deterrent sentences may be justified. However, the prevalence must be properly established by evidence and not merely asserted. So when considering prevalence, courts must have reliable evidence such as local crime stats or police reports rather than anecdotal assertions. Prevalence should not be used to impose disproportionate sentences, but can justify sentences at the higher end of a appropriate range of offence seriousness. Think of burglary or robberies that take place in an area and the deterrent effect that prevalence might bring into a sentence for a particular offender. Let me just look at how seriousness is determined and introduce you to a couple of the steps in the sentencing process. So step one is to assess culpability. Determine the offender's level of blame based on factors like planning, role in the offence and motivation intent. Step two is to assess the harm. Evaluate actual or risk harm to victims or society, considering physical, psychological, or financial impacts. Step three, find that starting point in the sentencing guidelines. Locate the appropriate starting point on the sentencing grid where culpability levels meet harm levels. And then step four is adjust for factors. So you look at aggravating and mitigating factors, things that move the sentence up or down within that category range. The process of determining seriousness is systematic and evidence-based. Courts must work through each step methodically, considering all relevant factors. The guidelines provide a structured approach, as we mentioned before, to ensure that similar offences of comparable seriousness receive similar sentences, promoting consistency across the criminal justice system. When you look at the sentencing guidelines, there are 4 statutory aggravating factors. Previous convictions, whether the code refers to courts to treat each previous conviction as an aggravating factor if reasonable to do so. Bail offences, section 64 requires courts to treat committing an offence while on bail as an aggravating factor. Hate crime, 66 and 67 of the code, requires aggravation for offences motivated by hostility based on race, religion, disability, sexual orientation or transgender identity. And for emergency workers, sentencing codes require aggravation for assaults on emergency workers. So the courts are required to, they must treat these as aggravating factors. The statutory aggravating factors must be considered by the court and will typically result in a high sentence within the appropriate range. They are mandated by legislation rather than just being part of the sentencing guidelines. Courts must state that they have considered these factors when they are presented. So what are the aggravating factors from the guidelines? So this all depends on the kind of offence we're focusing on. So beyond the statutory aggravating factors, the sentencing guidelines list numerous other factors that may increase the seriousness of an offence, including, for example, offence committed at night in the hours of darkness, victim was particularly vulnerable due to age or disability, high level of planning or sophistication, abuse of position or of trust or responsibility. So as examples, offence committed in the presence of children, use of a weapon, gratuitous violence, offence motivated by or demonstrating hostility based on protected characteristics, and attempts to conceal or dispose of the evidence. These factors are non-exhaustive and courts may consider other aggravating elements specific to the case before them. The courts are also required to look at mitigating factors. So what are mitigating factors? You have personal mitigation, offence mitigation, and possible post-offence mitigation as well. Factors relating to the offender's personal circumstances or characteristics that may justify a more lenient sentence, such as youth, lack of maturity, mental illness, or caring responsibilities. Then you have offence mitigation, factors relating to the commission of the offence that reduce the seriousness, such as minimal role in the group activity, lack of premeditation or provocation. And then you have offence post-mitigation, actions taken by the offender after the offence that demonstrates remorse or rehabilitation, such as voluntary reparations, cooperation with authorities, or seeking treatment. Common mitigating factors including no previous convictions or relevant or recent convictions, remorse, good character, serious medical condition, age, lack of maturity, sole or primary carer for dependent relatives, and cooperation with the investigation. In this case, R versus Berinskas, the Court of Appeal emphasised that personal mitigation, while important, cannot overwhelm the need for a sentence that reflects the seriousness of the offence. A very important point is mentioned on this slide, which is what sentence reduction does a defendant receive if they plead guilty? And you can see this is very important. It's a key issue looking at SBAQ questions. So if a person pleads guilty at the first stage, first available opportunity, which is that first magistrate's court hearing, they get a third off, up to a third off, maximum third off, which is 33%. If after the first hearing, after they get 25% off, on the day of the trial it's 10%, and then during the trial, I know, it's up to the judge. Section 73 of the Sentencing Act 2020 requires courts to consider the stage at which the defendant indicates their intention to plead guilty and the circumstances in which this indication was given. The Sentencing Council has issued definitive guidelines on reduction in sentences for guilty plea, which establishes a sliding scale of reductions. The first stage typically means the first hearing at which the plea is indicated. For example, for cases in the magistrate's court, this is usually the first appearance. For indictable only offences sent to the Crown Court, it's the first hearing in which at which a plea is requested, typically the plea and pre-trial hearing. Another feature in sentencing is what is known as the totality principle. The totality principle ensures that the total sentence is just and proportionate to the overall offending behaviour. It prevents the mechanical adding up of individual sentences that might result in an excessive total sentence. Imagine somebody committing offences of burglary, robbery and theft at the same time. If you add them all together, he'll get a higher sentence. So this is the idea of proportionate sentencing. Judicial discretion is key to this. When sentencing for multiple offences, judges must step back and consider whether the total sentence is proportionate. This may involve making some sentences concurrent rather than consecutive, something we're going to look at later, or reducing the length of individual sentences. And when it comes to the practical application, the principle is particularly important when dealing with numerous similar offences or a course of conduct where consecutive sentences might create a disproportionate severe total sentence. The totality principle is codified in section 120 of the Code and expanded upon in the Sentencing Council's definitive guidelines on totality. In R versus Purnell, the Court of Appeal emphasised that the final sentence must reflect all the offending behaviour and be just and proportionate. Another point to mention is this issue here, again features in SBAQs. What is offence taken into consideration, or TICs? TICs are additional offences that a defendant asks the court to take into consideration when being sentenced for the main offence. These are offences that the defendant admits to committing but has not been formally charged with. The process is the defendant must voluntarily admit to the TIC offences. They sign a schedule of TICs. It helps police have clear-up rates of offences. It's great for the police, which presented to the court. The judge confirms with the defendant in open court that they admit to these offences and wish them to be taken into consideration. Effect on sentence. TICs can increase the sentence for the main offence, but usually less than if they were charged separately. Once taken into consideration, these offences are treated as if the defendant had been convicted of them, preventing future prosecution. So that's the benefit for the defendant. The limitations: court may refuse to take offences into consideration if they are too numerous or serious, or if doing so would not adequately reflect the criminality involved. And TIC should generally be of a similar nature to the main offence. TICs are addressed in section 75 of the code. In R versus Miles, the Court of Appeal provided guidance on the proper approach to TICs, emphasising they should result in a moderate increase to the sentence for the main offence while still maintaining proportionality. So, how are sentences worked out? 8-step guide. So when you look at the sentencing guidelines for a lot of offences, you have an 8-step guide. So as I said, I encourage you to look at the sentencing guidelines, even though you don't need to know specific ones for the assessment, but just look at it so you can see it for yourself. So step 1, determine the offence category. Assess culpability and harm to determine the category of offence, which provides the starting point and the range. Step 2, the starting point and the category range. Identify the starting point within the appropriate category range based on the assessment of culpability and harm. Step 3, consider those aggravating and mitigating factors. Apply any aggravating and mitigating factors to adjust the sentences up or down within the category. And then step 4 is the reduction for guilty plea. Apply any reduction for guilty plea based on the stage at which the plea was indicated. As mentioned throughout these classes on sentencing, it's a structured approach, ensures that all relevant factors are considered in a systematic way. The starting point is not the minimum sentence, but represents the sentence for an offence with no additional aggravating mitigating factors. From this starting point, the courts then adjust the sentence based on the specific circumstances of the case. Look at part 2 of the step guide to sentencing. Step 5 is looking at that totality principle. Step 6 is looking at compensation and ancillary orders. Step 7 is reasons. The court must give reasons for and explain the effect of the sentence, including any reduction for guilty plea and consideration of alternatives to custody. Step 8 is the time on remand. That's also taken into account. So these final steps ensure that all procedural elements are met and that the sentence is communicated clearly to the defendant, victims and the public. Time spent on remand is credited towards the sentence on a day-for-day basis under section 329 of the code. The Court of Appeal has emphasised the importance of clear reasons for sentences in cases, so pay careful attention to spotting whether any reasons were given in an SBAQ question. So this is just an example of the 8-step guide. It's a case of theft from a shop. Defendant D stole alcohol worth £100 from a supermarket. D has 3 previous convictions for similar offences and was on community order at the time of the offence. D pleaded guilty at the first appearance and has expressed remorse. So when you look at the sentencing guidelines for theft, culpability, medium, some planning, harm, category 4, value 120. Step 2, starting point, the range is a fine. So the starting point is a fine. The range is discharge to medium community order. Step 3, look at the aggravating factors. Look at the mitigating factors. There's a previous conviction there, isn't there? Offence on community order. Mitigating remorse moved up to medium community order. Step 4, reduction of a third, early guilty plea. Remains medium community order, but fewer requirements maybe. And then steps 5 to 8, no multiple offences, consider compensation order for £100, explain the reasons and effect, and no time on remand to consider. So the final sentence could be community order for 12 months with requirements to complete 60 hours of unpaid work, reduced to 90 hours due to the guilty pleas, plus compensation order of 100. I said 120, it should be £100. Payable at £10 per week. The court would explain that the sentence reflects the seriousness of the offence, the defendant's criminal history, the early guilty plea, and the need for both punishment and rehabilitation. The compensation ensures the victim, the shop, is not left out of pocket. I hope that's a good example. And just look at some of the common mistakes in sentencing, and I've just a couple of slides here to look at the common mistakes. Misidentifying the maximum sentences. Remember the previous class on this. Watch that. Using wrong guidelines, double counting, miscalculating the guilty plea reduction. These are common errors, so please look out for them. common error, common mistakes in sentencing law, improper totality adjustments, inadequate reasons given, errors in the credit for time on remand. Very important to think about these as possible SBAQ type questions. Exam practice scenario, assault sentencing. Again, this is another example. Just, pause this, have a look again at how the guidelines work. Exam scenario again, burglary sentence. Just pause it, pause the slide, read it for yourself, have a look. And then we go back to those test your knowledge questions. Again, pause the slide, read the question, read the answers for yourself. Test your knowledge 2. Again, pause this video, read the slide for yourself, check the answer. Test your knowledge 3. Again, pause the slide, have a look at the answer. Finally, just remember, again, I can't emphasize it again, but watch all the videos in the SQE Prep Criminal Practice series. Understand the functioning legal knowledge yourself, what's been examined, check the SROA website, revise from a really good SQE book, participate in classes if you attend classes, prepare Q&A flashcards if they work for you, practice as many of those SBAQ questions as possible, subscribe to the channel, put your notifications on. Hope you found the class useful. See you in the next class, and thank you for watching.